Hello everyone, this is Dhanashri Chougale and you're watching Ganga Education. Welcome back to my channel. On this channel, you will get information regarding law and competitive examination related to law. So subscribe my channel and hit on a bell icon so that you can get information regarding upcoming videos. This is part 2 of Civil Judge Junior Division and Judicial Magistrate of First Class Preliminary Examination held in 2015 at Maharashtra. We have already discussed question number 1 to question number 25 and the link is given in description box. For this video, we will discuss from question number 26 to question number 50. So without further delay, let's get started. Question number 26. Audi alteram partem means option number 1, alternate remedy is available. Option number 2, hear the other side. Option number 3, tender of pardon. Option number 4, not to part with possession. And the correct answer is option number 2, hear the other side. Now question number 27. Ubi jus ibi remedium means option number 1, every right is attached with obligations. Option number 2, right without remedy is otiose. Option number 3, where there is a right, there is a remedy. Option number 4, none of the above. And the correct answer is option number 3, where there is a right, there is a remedy. Now question number 28. Which of the following statement of the witness is not admissible? Option number 1, girl told me that she was sexually assaulted. Option number 2, girl was crying and complained that she was assaulted. Option number 3, girl was depressed and did not say anything. Option number 4, none of the above. And the correct answer is option number 1, girl told me that she was sexually assaulted. This statement is not admissible. Now question number 29. The terms of a written contract can be proved by option number 1, oral evidence of a witness who witnessed the execution of contract. Option number 2, oral evidence of a witness who drafted it. Option number 3, producing that written contract itself or by secondary evidence when permissible. Option number 4, expert evidence. And the correct answer is option number 3, producing that written contract itself or by secondary evidence when permissible. Now question number 30. The expression res gestae means option number 1, the thing done in the course of transaction. Option number 2, a thing belonging to the guest. Option number 3, demeanor of the witness under examination in the court. Option number 4, a thing belonging to nobody. And the correct answer is option number 1, the things done in the course of transaction. Now question number 31. The expression dying declaration means option number 1, statement made by the person at the time of his death. Option number 2, declaration of a person in contemplation of death. Option number 3, statement of the deceased person as to his cause of death. Option number 4, declaration of a person on the deathbed about disposition of his property. And the correct answer is option number 3, statement of the deceased person as to his cause of death. Now question number 32. Confession means option number 1, any admission of the accused. Option number 2, admission of the facts constituting an offense. Option number 3, exculpatory statement of the accused. Option number 4, self-serving statement of the accused. And the correct answer is option number 2, admission of the fact constituting an offense. Now question number 33. Judgment in rem is option number 1, binding on the parties to the proceedings. Option number 2, binding on the parties and any person claiming through such parties. Option number 3, a judgment that binds the world. Option number 4, none of the above. And the correct answer is option number 3, a judgment that binds the world. Now question number 34. Which of the following is not an evidence within the meaning of section 3 of the Evidence Act? Option number 1, depositions of witnesses recorded at the trial. Option number 2, documents produced for inspection of the court. Option number 3, electronic record produced in the proceeding. Option number 4, report as to local investigation submitted by the commissioner appointed by court under Rule 9 of Order 26 of Civil Procedure Code. And the correct answer is option number 4, that is report as to local investigation submitted by the commissioner appointed by court under Rule 9 Order 26 of the Civil Procedure Code. Now question number 35. Opinion of elderly person in the society is option number 1, inadmissible in evidence being hearsay. Option number 2, admissible to prove general conduct and character of the parties. Option number 3, admissible to prove general custom or right. Option number 4, inadmissible as their opinion is irrelevant. And the correct answer is option number 3, admissible to prove general custom or right. Now question number 36. Printout of a photo taken with digital camera is option number 1, the original document. Option number 2, secondary evidence. Option number 3, primary evidence. Option number 4, neither primary nor secondary evidence. And the correct answer is option number 2, secondary evidence. Now question number 37. What is the object of contradicting the witness with his previous inconsistent statement? Option number 1, to challenge his veracity. Option number 2, to challenge his knowledge. Option number 3, to show he is interested witness. Option number 4, to fortify his veracity. And the correct answer is option number 1, to challenge his veracity. Now question number 38. Which of the following is an accurate proposition? Option number 1, lunatic is a competent witness. Option number 2, lunatic is not competent witness. Option number 3, lunatic is a competent witness when he is able to understand the question and give rational answers. And option number 4, none of the above. And the correct answer is option number 3, lunatic is a competent witness when he is able to understand the question and give rational answers. Now question number 39. Adverse inference may be drawn against the party when option number 1, he did not examine himself as witness. Option number 2, he did not participate in the proceedings. Option number 3, he failed to prove material document though produced. Option number 4, material evidence oral or documentary not produced though available. And the correct answer is option number 4, material evidence oral or documentary not produced though available. Now question number 40. When legal provisions provides that court shall presume a fact, it is option number 1, irrefutable presumption. Option number 2, permissive or discretionary presumption. Option number 3, refutable presumption. Option number 4, conclusive proof of the fact. And the correct answer is option number 3, refutable presumption. Now question number 41. Which of the following word is not related to principle of mens rea? Option number 1, dishonestly. Option number 2, voluntarily. Option number 3, fraudulently. Option number 4, cautiously. In good faith. And the correct answer is option number 4, cautiously in good faith. Now question number 42. Nothing is an offense when it is done by a child under option number 1, 5 years of age. Option number 2, 7 years of age. Option number 3, 12 years of age. Option number 4, 14 years of an age. And the correct answer is option number 2, 7 years of age. Now question number 43. The accused stabbed a man who was sexually assaulting her and she caused his death. She is option number 1, guilty of culpable homicide not amounting to murder. Option number 2, guilty of murder. Option number 3, guilty of no offense. Option number 4, guilty of causing death by rash act. And The correct answer is option number 3, guilty of no offense. Now question number 44. Making or publishing any imputations on someone who is dead. Option number 1 is no offense. Option number 2 amounts to an offense of defamation. Option number 3 amounts to defamation of his family members. Option number 4 is a civil wrong. And the correct answer is option number 2 amounts to an offense of defamation. Now question number 45. Causing death by rash and negligent act is option number 1 accidental death. Option number 2 culpable homicide not amounting to murder. Option number 3 neither culpable homicide nor murder nor accidental death. Option number 4 none of the above. And the correct answer is option number 4 none of the above. Now question number 46. Dislodging the tooth by a blow of fist is option number 1 an offense under section 325 IPC. Option number 2 an offense under section 323 IPC. Option number 3 an offense under section 324 IPC. Option number 4 an offense under section 326 IPC. And the correct answer is option number 1 an offense under section 325 IPC. Now question number 47. Theft is said to have been committed when the accused, option number 1, moved away the property of someone else. Option number 2, took away the property without the consent of the owner. Option number 3, dishonestly took away the movable property without consent of person in possession. Option number 4, dishonestly induced a person putting him in fear of injury to deliver the property to him. And the correct answer is option number 3, dishonestly took away the movable property without the consent of the person in possession. Question number 48. A man allowed his cart to proceed unattended along the road. It runs over a boy, causing fracture of his leg. He has committed an offense. Option number 1, voluntary causing grievous hurt. Option number 2, causing grievous hurt by rash and negligent act. Option number 3, voluntary causing hurt. Option number 4, no offense at all. And the correct answer is option number 2, causing grievous hurt by rash and negligent act. Now question number 49. A soldier fired on a mob under the orders of his superior officer and caused the death of a person. He has committed, option number 1, an offense of culpable homicide not amounting to murder. Option number 2, no offense. Option number 3, murder. Option number 4, an offense under section 304A of the Indian Penal Code. And the correct answer is option number 1, an offense of culpable homicide not amounting to murder. Now question number 50. In case of an offense punishable with fine only, imprisonment in default of payment of fine, option number 1, shall be rigorous. Option number 2, shall be simple. Option number 3, may be rigorous. Option number 4, may be simple. And the correct answer is option number 2, shall be simple. That's it for this video. We have discussed question number 26 to question number 50 in this video. In upcoming videos, we will solve remaining 50 questions. Thank you for listening.